9:30 a.m., October 18th, 2023. Welcome to the regular call meeting. Well, it's actually not a call meeting, it's a regular scheduled meeting, Joni, of the Danville Architectural Heritage Board. See, we have the city attorney present, Mr. Dexter. Thank you, sir. Good morning. Joni, do we have any city commissioners present?
No, sir.
Okay, if you reflect that in the minutes. Ms. Dixon. First piece of business, we have two new board members. One is present. John, since I just met you, I'm going to let you do your own introduction, but I know you're with the library. So if you just kind of for the record, let the folks know who you are.
Yeah, so I work with the library here in town. My role is local history librarian. My goal there is to create a comprehensive and active an archive for Danville and for Boyle County, where folks can come in and research from the primary source documents that we have there. I mean, we have letters back to 1756. We have the 1780s town plan. We have all types of stuff that are of a great value to the town. And right now, it's all in storage and it's kind of hard to access. So I want to make it more available to researchers and to the public. And so that's kind of why I'm there. And I'm trying to build connections in between all of the historical things in town, like the museums and the historic sites and the boards and historic preservation and things like that. So I'm happy to be here.
On account of us researchers, we thank you for that.
Very valuable. Glad to have you in the community. Now, we will not hold it against you. You mentioned you were someplace from Tennessee.
I am from eastern Tennessee, right by the mountains, but I moved to Kentucky as fast as I could.
Okay, all right, okay.
That's where the good people.
That's good, very good. That is in jest.
Whereabouts in eastern Tennessee?
Greenville.
Okay.
Right on the North Carolina line, just southwest of Johnson City, about an hour west of Asheville.
Used to do a lot of work in Afton, if you know where Afton's at.
Afton, yeah, my college is right by there.
Okay,
I grew up part of the time in Chucky.
okay.
I didn't get
Davy Crockett's home.
Yep.
Yep, very
First
good.
name is John.
Yes.
Boy,
And
you
the
can't
last
go wrong
name
there.
for the
No,
minutes.
that's a good one.
And last name for the record?
Can't hardly say it. It's one letter out of trouble. Nicholson. Thank you.
Very good, thank you, sir. Very good. Next order of business, if you've had a chance to look at the last meeting minutes,
I move there for approval.
I have motion to approve.
I second.
Any further discussion? All in favor? Aye.
Aye.
Very good on that. I'm going to interject a 3.5 on that, and something now we're up to full board strength, and we will come up, I think we'll have an election later on. But one of the things we have been missing for a while is a vice chair. You know, in my absence, who conducts the meeting. So I would entertain a nomination for a vice chair.
I'd like to nominate Darren Ogle to be a temporary vice chair until the other new member comes on, and then we can have an opportunity to elect a permanent vice chair and chair. That's my motion.
Following proper protocol there, Mr. Attorney, I would entertain a second.
Second.
Dana, second. Any further discussion? All in favor? Aye. Very good,
Congratulations.
Thank you.
very good. Our first order of business under point number 4 is 303 West Main Street painted sign. Do we have anyone present from, that's Copper and Oak? Joni?
No, sir.
I'm sorry.
You can see, you have in front of you the staff report.
Okay,
You also have in front of you the findings of facts. And this one is a little problematic in that it has already been completed. It was completed without the COA application or any application of planning and zoning. Saying that, there's a couple different things here. The sign is above the generally allowed area that we put signs or allow signs. We have turned down Farmers Bank in the past for doing a sign between the second and third floor. So that was a denial from this board. Now, saying that, that sign would have been bolted on the Farmers Bank. It would have been bolted in and causing issues with bolting in through the mortar. This is a painted sign. It's not permanent. It's, you know, you can paint over it at any time. So there's no real architectural issue with that. This is strictly on our guidelines saying that it's not appropriate for pedestrian orientation. And that's, you know, that's about where it's at. We need to come to a conclusion to this so that they can move on. They are under violation of planning and zoning currently.
I have a question. I know back some time ago, their adjoining building for La Casa Nostra,
Yes,
we had turned down a sign there, but the city commission overrode that and allowed the sign, correct?
yes,
My memory served me right?
that's correct.
If we turn this down, will their option be to go to the city commission, or what happens?
Yes, they will have that same option, I'm assuming,
Okay.
that they will go to the city commission. They will follow it as everyone else does. What makes this problematic is the work's already been done, so.
If I'm in order, I'd like to make a motion.
Certainly, sir.
I'd like to make a motion that we deny the request based upon what we have done in the past. We have told Farmers Bank's one that they basically could not do the same thing. I don't see how we can sit up here in good conscience, deny somebody directly across the street that they can't do it, and yet, okay, building directly across the street. And having said that, I would like to include in my motion that staff work with the people involved here to come up with a solution that's suitable to everyone with the sign that's in compliance. If that motion makes any sense, that's my motion.
Let me make a comment about that. I'm in agreement with your motion, but need to comment a little bit. We did have trouble with next door signage, and we asked them to come back and with some alternatives. They chose to go directly back to the council and basically work around us. The council, in their infinite wisdom, gave him approval to go ahead with the signage that he wanted. And I think that that's just exactly where we're going on this application as well, being the same restaurant owner. So it is a very good-looking sign. From a purely design perspective, I think it was executed very nicely, just like the restaurant next door. But I think we have no choice but to deny the application, knowing full well that the council's going to take the power out of our hands anyway. So I'll second it.
I agree with what Mr. Michael is saying. However, we do know where this will head, and I think that it should be approved with the notice that this should not set a precedent, because we have denied others. But because that other sign is there at the exact same level, it does not disturb the historic nature of the downtown. It's typographically, it has a historic quality to it, and I just don't see the point of making enemies when we know it's going to be approved. I just think we have to say this is a unique situation
one quick comment. I just don't see how we can sit here and in good conscience tell somebody 3 months ago across the street they can't do that. And then come along and okay, somebody 3 months later, and I would like the minutes to reflect that, to go directly to the city commission. To me, that's almost a point of discrimination. It's kind of strong, Stephen, but,
Well, I think your staff indicated that there were differences as far as one being a painted sign and one being permanently mounted and drilled into the mortar, which would create distinctions under the law that would make it very different. I understand the perception, Mayor, but, you know.
That's not the issue. The issue is our credibility. You know, if we're gonna tell you today, you can do this, and tomorrow, she comes along and says we can't, then I don't need to be sitting on this board, quite frankly.
Is our ordinance pretty specific? It is or is not in compliance, and can we as a board override that ordinance?
You have no authority to override. You're acting under the design guidelines as you perceive them to be, which is what the commission does upon appeal as well. So, Mr. Noga, I understand your frustration somewhat with the process. However, I'd like to note that it is an applicant's exercise of rights to choose which manner in which to work with the city of Danville. So they're bound to come to you first, but if they choose to go to the city commission, you may perceive that to be a workaround, but an exercise of someone's rights should not have some negative connotation associated with it.
I agree, it's their right to do that. And
Right.
if they do that, that's good, but I just can't envision the city commission telling somebody or supporting, I mean, Stephen, it's contradictory, you know that, don't you?
Well, contradictory to what, Mayor?
You can't tell somebody today one thing and then turn around and tell them next month.
Well, I think what Joni had pointed out to you was that the differences in the Farmers Bank allegedly, and I have not reviewed that application, but based upon staff's comments, it was not a painted sign. It was a permanent sign that would be drilled into the mortar of the building, so therein lies itself. It's an apples to oranges comparison. If it were, as you said, a painted sign at that same level that was denied at Farmers Bank, it could be, as you said, an inapplicable or a fair, inequitable application of the rules.
Well said.
But in this case, as Ms. Dixon does point out, the level of the sign is commensurate with a neighboring property at this time. And it is a painted sign. It is not a permanently affixed sign, which in my mind provides enough differentiation to allow a different conclusion if you so desire.
It's not necessarily the sign that concerns me, I mean, you just can't tell somebody today one thing and tell somebody the next day something opposite, in my opinion. And that's what I struggle with.
And if the facts are identical, I concur. However, if the facts aren't identical, then they beckon perhaps a different conclusion.
A sign's a sign's a sign.
Well, but not under our design guidelines. So whether it's painted or it's mounted creates a very different analysis under the city's design guidelines.
Let me just clarify one thing that you said. I believe on the Italian restaurant, can't remember the name of it, we asked them to come back with alternatives. They chose to work around us. They weren't appealing. They were working around us rather than coming back and working with us. That's the distinction.
My memory of that was that there was a denial of the COA and said to come back, which gave them an appealable measure. So in that around, you're using the language of workaround. I'm just saying from a technical standpoint, I don't think that language is healthy, particularly due to the fact that the applicant was exercising a right provided under city ordinance. And furthermore, it's the city of Danville's ordinance. It's the commission's to enforce. They use you in an advisory opinion to take those matters and your subjective opinion in the application of those rules. And so in the exercise of their elected duties, they shouldn't be seen and viewed as a point as working around you either, even though you may feel it that way, because they are the ultimate arbiter of the values of the downtown district or this community. You are a tool and an important step in the subjective review of those design guidelines, but ultimately they reside with the Board of Commissioners of the City of Danville.
So in the future, asking an applicant to work with us is not productive.
It depends upon the applicant, and it depends upon the end goal, but the applicant's not required to work with you. If they have a
There,
solution.
that's my point.
Yeah, if
You've made my point.
If they have a solution that they want to see to finality, they have an avenue under the ordinance to do so.
All right.
I would ask that when we do make our motions, that they really need to reflect why we're doing it as opposed to in align with the guidelines. I understand what you're saying, Mayor, but we have to deny or accept it per the guidelines. And that has to be the design guidelines as they are applied to signs.
For a point of clarification, can you restate the motion?
Well, I didn't write down what you said. I wrote down what isn't complete. I wrote down that you moved to deny it because it was not in compliance with our guidelines.
But I'd like the minutes to reflect that a step further of what my motion really meant was, was.
Well, I think the minutes, properly reflected minutes should show what the motion is, and then after it's seconded, it can reflect what comments
Yeah,
you
we'll
had.
put that in
So
discussion.
those comments should be under the discussion rather as being attached to the actual motion themselves.
Thank you. Good point.
Have a motion, have some discussion. Did we have a second somewhere?
I did second John's motion.
You did second John's motion. Therefore, any other further discussion?
Call for the question.
All in favor? Aye.
Aye.
All opposed?
Aye. Or nay, I guess.
Nay, we have 3-2. My count. All right.
No, 4 to 1.
No.
No, he voted, those two, us three. Okay.
Okay. It passes.
Okay,
The motion passes, the COA denying the COA.
yes. Item number 2, 217 South Third Street. Sign in the window. You want to give us background on that, Joni? Do we have a representative here for Ephraim McDowell?
No.
Okay.
I've had some discussions with Ms. Strevel regarding this sign. I will tell you, you have the staff report in front of you. The findings of the facts are, the proposed sign is a window graphic, and therefore it is the type that is allowed within the district. If you look on, it is cumulatively with all of the window space, it meets our 25% guideline. What I will say, it is somewhat out of character for the district. Because it is such a large sign and takes up an entire window, it does not have the retail distinction or the retail quality that we're looking for the district. So I will leave that to your discussion. You can find either up or down on this one as well. I'm happy to work with them further if you wish to send it back to them. And I've already discussed with you, if it is an impermanent sign and hung inside the window, then we would have no purview over that.
Okay.
It's basically because it's attached to the building.
You want me to go? If I can make a motion, I'd like to make a motion to deny the application. My opinion is that the sign is too large, and it's not really a sign, it's more of a graphic. It's not identifying the use that's in the building. I think that an alternative, because that is a long stretch, the parking garage needs some graphics, okay? And I think that an easy alternative is to ask them to place their sign set in behind the window storefront. They've got open space there to be able to do that. I think they would be able to communicate their pride and their medical staff, which is commendable, but just not on the glass.
I have a motion to deny. Any further discussion?
I second.
Have a second. Any further discussion?
It's a billboard. It's an ad. It's
Yes.
not a sign.
It's a highway billboard.
Yeah.
Very good, very good.
They can put that message out, but not that way.
Okay. All in favor of the motion to deny, say aye.
Aye.
Apparently none opposed. Very good. For the next item of business, first of all, I will recuse myself. And if you'll pass that over to Jenny, that's the signed minutes.
And Tom, just for the record, under our ethics ordinance, it requires you to say why you're recusing yourself before you leave the room, and I'm just doing that for your protection,
Oh,
sir.
thank you, thank you. I am a party, I think would be the correct description in the request coming before you, or at least I'm an adjoining property owner. Is that?
That's sufficient.
Is that sufficient? Very good. Thank you. You're in charge, Mr. Noble.
Thank you. Okay, the application, item for 116 East Main Street. Joni, staff report?
Yes, sir, you have the staff report in front of you. The findings of facts, as they are pertaining to our design guidelines. It is not a contributing structure to the district. It is not of the appropriate age to be a contributing structure. It's not like it is a masonry wall constructed in 1820. It's a concrete retaining wall. The proposed retaining wall is the appropriate scale for the building as far as our design guidelines are concerned. There's a strong edge present in the design guidelines, which is also required for landscape. The proposed retaining wall, it does not impede any public right-of-way. It doesn't close up any of the public access to either business.
What do you mean by a strong edge?
In our design guidelines, they like to see a strong sidewalk edge, and what they do not want to see, or what they would not prefer, is a gravel pad area. They like to see a defined area for parking.
Do we know when that wall was installed?
I believe somewhere in the 90s, is that correct? 1990s,
Maybe 2006, something.
2006.
Okay. In excess of 10 years ago.
Yeah, yes, sir. But for us to for it to be a part of the landscape that is a contributing structure, it has to be 50 years old, or it does not meet that threshold.
I understand, okay. I believe there's someone to speak on this item.
I'm here for Mr. Todd. I think Mr. Rice is here for the petition.
Okay. Mr. Rice?
Well, I think that Ms. House has already touched on a number of our initial concerns, which are just whether or not that this is something that,
Can you speak into the microphone, please?
yes, I apologize. I believe Ms. House has already touched on, or at least began to touch on some of our concerns, which is just, this application was filed just, I believe, upon representation of the party in opposition to removal of the wall, that it needed to be done. Our concern is whether or not under the applicable zoning guidelines that reference, I believe it's chapter 313, for the certificate of appropriateness, whether or not this follows or falls into a historic structure that, that gives this board the authority to comment on the certificate of appropriateness. So, one, the age; two, taking a look at the Historic Overlay District Design Guidelines, Chapter 7, 7.1.2, that references actual buildings and historic structures, which I believe Ms. House has stated that this wall is not.
It is not.
So, don't believe that there should be any problem with removing the wall as agreed to by the parties when this agreement was entered into years ago.
So you're saying that the two parties are in agreement with relocating the wall?
No, I don't believe that they are in agreement to relocating the wall. I think the question is whether or not it's an issue, the relocation of the wall is an issue for this board to necessarily decide, given the age of the structure, the fact that it's not a building, the fact that it doesn't seem to fall into those types of structures that are contemplated under 313 and the overlay guidelines.
Well, we have the benefit of an attorney here. Any comments?
I do have comments if we want to allow, though, other counsel to speak, and I'm happy and ready to comment
Okay.
after the parties have been heard, though.
Okay. Okay. Thank you.
Thank you. Good morning. Here on behalf of Mr. Tom Ty, who's the adjoining property owner. Mr. Ty is opposed to the certificate of appropriateness primarily because this retaining wall he's the primary and plurality owner of the retaining wall where it's located. There was a survey conducted, Mr. Ty had that conducted in August. I have a copy of that which I can distribute to the membership. 48% of that wall was located on Mr. Ty's property, 40% is directly on the line, 12% is located on Mr. Brown's property, was the conclusion of that survey. That survey's been provided to Mr. Brown. So I think under the guidelines that you have here, the property owners have to file for a certificate of appropriateness. Of course, Mr. Ty has not, he has not joined in the application to move this wall to the east. I think 2 feet is what Mr. Brown is requesting. Second, I don't think that you see a complete project description that has been provided by Mr. Brown. It's, when I reviewed the certificate, it was just a very basic outline of what he intended to do. There's really no idea of how long it would take, the cost, what issues may occur from the removal. Third, I mean, I think you have to ask what purpose would it serve to move the wall as it is 2 feet to the east. I think that could, depending on the survey, that could create a trespass onto Mr. Ty's property, depending on, you know, the final outlay of this wall. Would this project harm Mr. Ty's property with dirt, you know, being thrown around? I don't know. I don't know. I think that's why you need a full project description, which has not been provided. And third, or fourth, I think this wall, as Mr. Rice alluded to, this wall was constructed pursuant to an encroachment agreement. At one point in time, of course, Mr. Brown was all for the wall or wouldn't obviously be there. So now, he obviously alluded to that agreement, so now obviously something has changed and it's gone from I wanted it there to I don't want it there to maybe now I want to move it. So sort of a moving target as to what the request is. But I am happy to provide the survey that Mr. Ty had commissioned back in August that shows that the wall is in fact 48% on his property, which the encroachment agreement didn't have the benefit of that survey when it was entered into. So, thank you.
Just so I have the facts right, so are we talking about relocating just the part that is quote-unquote encroaching onto the neighbor?
I don't have the answer to that. Mr. Brown would have to speak to what part he wants to move. My
Can I get a response to that? What extent of the wall?
Excuse me, can you take the microphone, please, so we can hear? Thank you.
I'm just trying to get the facts straight, whether we have standing here or not.
So, from Mr. Brown's perspective, that portion of the property, which I understand may now be in dispute because of this survey, the portion of the property on which the wall sits, Mr. Brown is seeking to be able to once again use and reclaim that portion of his property where the wall sits in order to be able to utilize that for parking for his business that is there. Now, I think this encroachment agreement was entered into, I believe, by Mr. Bowling as the previous property owner, and Mr. Ty. So and that's fine, but to say that Mr. Brown wanted the wall there, was fine with the wall there, allowed the wall to be placed there, now wants it removed, I think is a little bit of a mischaracterization there. He took the property subject to whatever easements and restrictions and other issues were present at the time. That wall has stayed for the duration that he's owned the property up until such time as now he needs that portion of his property back. The parties, when they entered into this agreement, stated that Mr. Ty, or whoever the property owner would be at that time, would agree to move that wall if and when the time arose within a specific time period. That time period has came. The demand has been made to move the wall needs to be moved, so that way that portion of the property on which the wall sits belonging to Mr. Brown can be reclaimed so he can use that portion of the property that is his.
Okay.
I mean, I think that's the issue, so I don't necessarily know if this isn't more a dispute between the two parties that needs to be ironed out as opposed to something that this board needs to presently decide. If they do need to decide, we would say that the certificate does need to be issued. It is appropriate for him to reclaim that portion of the property that belongs to him so that he can utilize it the way that he sees fit, as the parties intended when they entered into that agreement.
Yes.
Just very briefly, I would just ask what portion of the property would we be talking about here? Because from the survey that we have, only 12% of it's on his property. The rest of it is on the line, or, I've got the numbers here. So I don't think that has been detailed in the application. I think when you look at the application, it simply refers to a wall. It does not refer to a specific portion of it in any shape or form. So the way I read this application is that it's the entire wall, unless I'm misreading it. And so if we're talking about a portion of it, then I think that needs to be readily identified by Mr. Brown. I don't think it has been readily identified in this application.
Mr. Noble, I'm ready to issue my comments now, if it be appropriate with the parties having had
Yes,
a chance
please.
to air their sides. Sure.
Because this sounds like a legal thing.
Well, it is my conclusion and recommendation that you do not rule on this matter, that it be stricken as an inappropriate matter for this board's consideration. What is clear after communication from the parties is that there is an apparent or an alleged boundary dispute which is not suitable for rendering in this court or this hearing body, rather, and that conceivably, since it is an existing retaining wall built in the time in which our design guidelines were in place at that time, it was perceived or acknowledged to be appropriate when built. Therefore, a mere moving of an existing approved structure would not even require a certificate of appropriateness anyhow. To the extent it is or is not on a current or an adjacent property owner, that matter would be resolved in the Boyle County court system to a degree, probably circuit court, to iron out where that line actually is. That's a boundary dispute, and then since their design guidelines aren't impacted if the replacement wall, if approved, is as it exists today. The only matter which it would come before this board is that if the wall was going to be replaced with a dramatically different wall, bricked, 6 feet tall, chain link, that type of matter would have to come back here for an appropriate rendering. However, in this case, it is not appropriate to make any consideration, comment, or rendering on the application before you. And I think it should therefore just be tabled indefinitely without further action on your part, and that is my recommendation.
I make a motion, we table this issue indefinitely.
Do I have a second?
Second.
I believe we have tabled this motion for a future date.
No, I believe it was indefinitely, which means it won't come off the table, just so the parties are clear. It is on the table to die.
And if you go with Robert's Rules of Order, the people who make the motion have to make the motion to bring it off the table?
I will say this about Robert's Rules of Order. We use them as a loose guide, but we don't die on that mountain. So, while we use them to lead efficient meetings.
Come up in court and say, well, you.
That's right.
Then to the extent such a motion would need to be made, we'll make it to pull it off the table.
Can I just say one thing? We did do the right thing by doing what Joni asked us. We didn't realize at the time that it was not a factor as far as this board.
And that's okay, and that's okay. And my comment isn't to spill any type of derogatory comments on any of the parties. It's merely to just center the DAHB on what their intention and purpose is under city ordinance, and it just doesn't cover the matter that's before them today.
So we're good. Thank you all.
See you.
Okay, I believe that's all the COA hearings. Joni, I believe you have some administrative approvals.
Yes, sir, for 440 West Martin Luther King Street, it was a sign which was appropriate via our guidelines, and it was administratively approved. You have the staff report and that information. And also, 311 West Main Street was administratively approved. It was of the type and like sign that is appropriate for the district, and it met the sign guidelines, and there seemed to be no issues with it, so it was also administratively approved. Those are the two that have been done in the last 3 months. The others were more problematic. That's why you got to see them today.
Well, thank you for that. I believe that completes the agenda. And do I have an emotion to adjourn?
So move. Boy, it's really nice to have the august people here today that we do have, so.
It's a pleasure being here.
It does help.